Well, good afternoon, everybody. Our numbers seem to have stabilised around 80 people, which is fabulous. Thank you very much indeed, everybody, for joining us, and welcome to our webinar on indirect discrimination. I'm Henrietta Hill, and my fellow presenter is Sue Sleeman. We're very pleased indeed to see so many of you, at least on screen. It'd be much nicer, of course, if we could see you in person. And today's webinar is part of an important series of work that we're doing here in Chambers to celebrate 10 years of the Equality Act. I'm sure Sue won't mind me saying that both she and I remember the law before the Equality Act and have watched it develop over the last decade, and can see the challenges and the opportunities that it brings. It's particularly nice for me to know that there are so many people here from different backgrounds. So among the audience, I know that you can't all see each other, and that's obviously unfortunate, but we have a real mixture of people from employment law and other backgrounds. So as somebody who doesn't in fact primarily practice anymore in employment law, I do mainly discrimination in the non-employment sphere. Sue, you will hear, does much more employment law work. It's always very refreshing and reassuring to see people taking an interest in discrimination law from different backgrounds. I really hope that in the course of the next hour and a half, we can teach you something, perhaps bring some new cases from different spheres to your attention. We're going to do the best we can to pull together the key cases on indirect discrimination, and then some slightly more unusual examples that you may not have come across. This is the second of our series of seminars on key concepts within the discrimination law framework. So we've already had one session. This session on indirect discrimination will be followed by another. And then we hope that all of these key concepts sessions will be available to you in future if you wish. We intend to follow these sessions with more sector-specific training programs, about which more will be announced in due course. We're broadly planning to divide the presentations between the two of us. As you can see from the slide helpfully on the screen, what we're hoping to do, and I hope this will work and be interesting to you all, is take you on something of a journey through the last decade. So Sue will present first of all and broadly take you through the new, as it then was prior to in fact the passage of the Equality Act, definition of indirect discrimination, and look very broadly at the cases that developed in the first 5 years of the Equality Act's life. I will then pick up with some more recent developments, and in particular try and give some examples of cases that you may not have come across in fields outside employment. And we'll try and pull the threads together at the end of the session with a piece that looks forward. As I've indicated, we have a real range of people here, so we are very much looking forward to your questions at the end. Please understand that some people here have a lot of knowledge of the discrimination law framework and some have slightly less, and some are bringing different perspectives. So we are opening up the questions with some excitement, perhaps some trepidation as well, from me anyway, but we very much hope that this will be an interesting session for all of you. So I don't think I need to remind you all of the general rules. I think people are being muted if they're not speaking. There is a Q&A function that you're welcome to use to put questions in, but we do, I think, broadly plan to take our questions at the end. So without further ado, I'll perhaps hand over now to my fellow co-speaker, to Sue, to begin with the first 5 years of indirect discrimination under the Equality Act.
Thank you very much, Henrietta, for that introduction. And yes, it is indeed a great pleasure to be participating in this seminar on perhaps a slightly a less frequently used aspect of the Equality Act. I think there are other sections that most of us who are practicing regularly in the employment field certainly rely on more frequently than indirect discrimination. I think we might hear some observations about the reasons for that towards the end. As Henrietta said in her introduction, we've decided broadly to split today's seminar into chronological chunks because we're celebrating 10 years, so that seemed like a logical approach. There will be a little bit of variation from that because there are some key concepts that were established later on but are so fundamental it would be illogical not to refer to them in the early section. But essentially what I'm going to do in my first section is to give a quick overview of the Equality Act it being a new approach to discrimination, as Henrietta said, we're then going to move on to look at the definition of indirect discrimination, which is the focus of today's session, under Section 19 of the Equality Act. And in order to really understand more about how that works and what it is intended to cure or to prohibit or to minimise the adverse effects, we're going to look at the distinction between direct and indirect discrimination, and then move on to consider the policy behind the prohibition of indirect discrimination. We'll also look at, and this is the point where we get a little bit out of the chronological order, the traditional definition, which was in the Sex Discrimination Act and the other original discrimination statutes dating back to the 1970s, why that had become problematic, the various difficulties that arose. And then we're going to have a look at some of the key cases broadly from my period, although the one that predates, on common issues such as the PCP, the application of the PCP to others, and particular disadvantage. Can we have the next slide, please, Sean? Thank you very much. You may have picked up that Sean is controlling the slides for us very helpfully this afternoon. So a very brief overview, introduction to the Equality Act of 2010. And as Henry says, we were both around and dealing with the predecessor legislation, which seems like a very long time ago now. We can see from the slide that's on the screen now, so most of the provisions came into effect from the 1st of October of 2010. And I've just set out at the second bullet point an extract from the introductory text to the Act. And you can see I've highlighted really a key passage at the start. So its purpose is to reform and harmonise equality law and to restate the greater part of the enactments relating to discrimination and harassment related to personal characteristics. There are then some other aspects that are less relevant to today's seminar, but moving on down towards the bottom of the extract on the screen, you can see it's also to increase equality of opportunity, to amend the law relating to rights and responsibilities in family relationships and for connected purposes. So you'll appreciate from that, and probably from your own knowledge, that of course this wasn't the first time we had most of these provisions. They all predated this. There were separate acts dealing with equal pay, which dated back from memory, I think it was 1970, and then we had the Sex Discrimination Act and the Race Relations Act, both from around the mid-1970s, and then the Disability Discrimination Act from the mid-1990s, and we then had the other employment equality regulations from 2003 and 2006 dealing with sexual orientation, religion and belief, and age. So the position shortly prior to the coming into force of the Equality Act was that many of the provisions already existed in some form or another, but it was a fragmented regime, and also many of the provisions were very long-standing. So it really was ripe for reform and harmonisation. Can we have the next slide, please, Sean? Thank you. So I thought it was helpful just to have a look at the whole structure of the Equality Act, because certainly anyone who's in my position of being a regular employment practitioner dealing with Equality Act cases on a very regular basis, we tend to, I think there's three parts here that I look at probably on a weekly basis. That's part 2, dealing with the protected characteristics and prohibited conduct. There's also some other provisions around prohibited conduct in part 8. Part 5, which is work, that's where the bulk of my practice is situated, and then the enforcement provisions in part 9. But looking at the entire list, you can see, of course, that it goes very, very much wider than that. Part 1, socioeconomic inequalities, of course, was never brought into force, but then you can see the other areas of remit, services and public functions, premises work, education associations, many of which we don't come into contact with on a regular basis. So interesting for me, it was interesting anyway, feeling I was someone who was relatively familiar with the Act, to see just how wide it is and how much of it I've never had any cause to deal with. If we can have the next slide, please, Sean. So I should say, I think Henry mentioned in her introduction, this is the second in this series of seminars, and the first is worth a view. If you didn't either attend at the time or we haven't viewed it since, it's certainly worth looking at. It's two of our colleagues from the employment discrimination team, David Stevenson and Amanda Hart, looking at direct discrimination and harassment. And David gives a bit more of a detailed introduction to the Act generally. So that was part of the reason why I decided not to cover it in any great detail. And if you haven't seen that, I would recommend that you do so. So we can move on then to looking at the nub of today's seminar. Oh, sorry, Sharma, I hadn't started speaking to the previous slide yet. Section 19. So the nub of today's section is indirect discrimination, and section 19 of the Equality Act is where the relevant provisions are located. And you can see at a glance how full that slide is. It's not a straightforward or easy to digest definition by any stretch of the imagination, even when you're dealing with it on a fairly regular basis. And I find that whenever I'm doing a case which involves a claim of indirect discrimination, I really have to have section 19 either written down somewhere or up on a screen near me the whole time, so that I don't overlook part of it or mistake some of the wording, because it really isn't that easy to keep in one's mind all the time. So subsection 1 tells us that a person discriminates against another if they apply a provision, criterion or practice which is discriminatory in relation to a relevant protected characteristic of the victims. Provision, criterion or practice is now always referred to as PCP. I'm afraid employment law is very heavy on acronyms, second only, I think, to line of duty in that respect. And of course, the first part, subsection 1, doesn't really tell us very much, because it just talks about it being discriminatory. So then we have to look to subsection 2, which explains what is meant by a PCP being discriminatory. It occurs where A applies, excuse me, or would apply to persons with whom B does not share the characteristic, and the PCP then puts or would put people with whom B shares the characteristic at a particular disadvantage when compared with persons with whom B doesn't share it. Subsection C, it puts or would put B at that disadvantage. And finally, A can't show that it's a proportionate means of achieving a legitimate aim. So as I mentioned at the outset, that the structure of it is quite complex. There are a number of different components, and you have to work your way through all of them to achieve an understanding. And of course, you have to get home on each of those if you want to succeed in a case on indirect discrimination. Subsection 3 sets out the relevant protected characteristics, and you will see that it omits pregnancy and maternity, and that simply reflects the scope of the EU provisions on which this particular legislation was based. And of course, in any event, if you have indirect discrimination on grounds of pregnancy or maternity, it's very likely, if not certain, to be sex discrimination. So you would certainly bring the claim on that basis. A point which certainly wasn't now still in my mind is that the Disability Discrimination Act of 1995 didn't have any provisions that prohibited indirect discrimination cases on grounds of disability. I might have been aware of it at the time, but it certainly didn't. It came as a bit of a surprise to me when I saw that. So if we can move forward to the next slide, please, Sean. I think it's helpful in terms of understanding the purpose and effect of indirect discrimination to compare it with direct discrimination. And we've got a passage here from the judgment of Lady Hale in the case of Crown governing body of JFS, going back to 2010, the year in which the Equality Act was brought into force. And again, I've highlighted the key passage in yellow towards the bottom half of that paragraph. And she said, having noted that direct discrimination aims to achieve formal equality of treatment, there must be no less favourable treatment of between otherwise similarly situated people on grounds of colour, race, nationality, or ethnic or national origins. She was only referring to that particular protected characteristic because that's what the case involved, but obviously the same is true of the other protected characteristics. Indirect discrimination, however, looks beyond formal equality towards a more substantive equality of results, and that seems to me a very apposite way of expressing it. So criteria which appear neutral on their face may have a disproportionately adverse impact on people of a particular colour, race, nationality, ethnic or national origins. And just to note, the definition of direct discrimination, of course, is that arises where, because of a protected characteristic, A treats B less favourably than A treats or would treat others. So there are two elements to a direct discrimination claim: less favourable treatment and the reason for it. So I think that the distinction is beautifully encapsulated there by the words of Lady Hale, and we might think of it perhaps as a slightly more subtle form of discrimination, but nevertheless one which still has an adverse effect on those who have the protected characteristic. Could we have the next slide, please, Sean? Thank you very much. Lady Hale again here, this time from the case of Homer, and this is one that I think we'll be revisiting a number of times in the course of this seminar. It's a very useful judgment in many ways. It's an age discrimination, indirect age discrimination claim brought by a man who had previously been a police officer. He'd retired and gone back to work, I think in the legal department of the force, and there was a pay structure which meant that in order to progress beyond a particular threshold, various thresholds, you had to have a law degree or equivalent. He didn't have a law degree. He'd met the qualification requirements when he joined, and of course, given that he'd already had a career as a police officer and was fairly advanced in years, he didn't want, it wasn't practicable for him then to take on the several years it would take to study for and acquire a law degree. So he was arguing that that amounted to indirect age discrimination. And Lady Hale made this observation: it's an attempt, indirect discrimination is an attempt to level the playing field by subjecting to scrutiny requirements which look neutral on their face, but in reality work to the comparative disadvantage of people with a particular protected characteristic, and going on to note that scrutiny might ultimately lead to the conclusion that the requirement can be justified. And of course, it's relevant to note that in cases brought on the basis of direct discrimination, section 13, there is no justification defence. If you make out less favourable treatment and the reason for the treatment, then that is it, you win, with the one exception of age. So there is a justification defence for direct discrimination claims on grounds of age, but it is unique in that respect. Next slide. Oh yes, well done, well anticipated. Thanks a lot, Sean. So I am here, you'll see from the date of Essop trespassing a little bit on Henrietta's slice of the 10-year period, but Essop is such a seminal decision on indirect discrimination. It's impossible really to avoid revisiting various aspects of it, and it would make no sense to have gone on without having acknowledged it. And it gives such a clear and succinct explanation of the distinction between the two. It's Lady Hale again. So direct discrimination expressly requires a causal link between the less favourable treatment and the protected characteristic, but indirect discrimination does not. Instead, it requires a causal link between the PCP and the particular disadvantage suffered by the group and the individual. So that's really the end of the section explaining broadly what it is and why it's prohibited, what the rationale was for prohibiting it. And now we're going to have a look at the way it's been transposed into law at different times. So this is what's become known as the traditional test. It was section 1B of the original Sex Discrimination Act. There were equivalent provisions in the Race Relations Act of 1976, but there's only so many slides you can replicate in the course of a presentation. So this is the original wording from that act, and you will see I've highlighted in yellow the significant differences in language from the wording of section 19. So the first notable departure from the current wording is in subsection 1b. We've got the words requirement or condition rather than PCP, which is the current terminology. And then in the next subsection 1b1, the proportion of women who can comply with it is considerably smaller than the proportion of men. And that is different from the current wording, which is that the PCP puts the women at a particular disadvantage. And we'll come on to look at why that really needed to be changed, why it became so problematic in due course. And then you'll see at subsection 1b2, cannot show to be justifiable. And now, of course, that's been split into the much more familiar two-part formula that we see in other areas of law, which is legitimate aim and then proportionate means of achieving that legitimate aim. So those were the original provisions. And as I say, at the bottom of the slide, there was something very similar, if not identical, from memory in the 1976 Race Relations Act. Could we have the next slide, please, Sean? Thank you very much. So the difficulties with that traditional test arose really because of the, well, partly because of the requirement or condition, but then significantly in relation to the proportion of women who can comply, and the need for that proportion to be considerably smaller than the proportion of men. I think you can pick up just from listening to that formula of words. It's a very, very difficult concept to unwrap and to decide what sort of evidence you need to discharge a burden of proof if you're bringing a case under that provision. And so very often courts were having to look at statistical evidence. Sometimes it might not be available, it might be available, it might not show what you would expect to be the effect. Sometimes how big did the difference have to be between the two groups, the ones who could comply and the ones who couldn't comply. And it was, so the whole thing, just you had to identify the pool for comparison. Was it women trained drivers in London? Was it women trained drivers in the UK or in Europe? It was such, there were so many ponderables associated with that test that it took up an awful lot of court time, and I think probably a lot of claimants failed to get home in circumstances where really, given the underlying purpose of the legislation, that they should have. And those difficulties, oh sorry Charlotte, I haven't dealt with the last bit, thank you. The difficulties were recognised from a fairly early stage. You'll see I've referred there to London Underground and Edwards, which is a 1999 case, and it involved an area, a matter that has been a recurrent theme throughout indirect discrimination cases. So a female train driver, train operator with childcare responsibilities, and that combination of work commitments, particularly in relation to hours, shifts, flexibility, those kind of issues, and childcare have been, as I say, a recurrent theme throughout the development of case law in this area. So in this case, the shift system that she'd managed to juggle her childcare, I think she was a single parent, I think she had 3 children. She'd been able to juggle it so that she was able to manage the 2 jobs, but then the employers changed the shift system, which would have meant that she needed to work extremely long hours in order to avoid nights, and obviously she couldn't work nights because of childcare reasons. She was a single parent. I just found the relevant part in my note. And the appeal, in fact, in this case, was really around the approach to the pool for comparison. And the Court of Appeal made this very helpful observation that the tribunal doesn't sit in blinkers, and therefore it was entitled to take into account of its own knowledge about the proportionately larger number of women than men who work and who have primary childcare responsibilities. Next slide, please, Sean. Thank you very much. So the Sex Discrimination Act was then amended because of those, partly because of those problems, partly also because of developments from European law, the Burden of Proof Directive. The wording was amended with effect from 2001. And what you see on the screen, the amended, what's become known as the new test, although it's not, being that it dates back to 2001, it's not terribly new now. But you now see a wording much more similar to the wording we now have under Section 19. So we've moved away from requirement or condition, which of course is arguably considerably narrower than PCP, which we now have and was in the Sex Discrimination Act after the amendment. And we've also got particular disadvantage rather than the proportion of women being who are able to comply being considerably smaller than the proportion of men. And then, as you can see in section 1(2)(b), Revenue 3, we've got the what was just described as justify in the previous formula is now split as we in the much more familiar formula legitimate aim and proportionate means of achieving that legitimate aim. The Race Relations Act of 1976 was amended in a very similar way, and then this new test was then contained in the regulations that came into force in 2003 and 2006, dealing with discrimination on the basis of religion and belief, sexual orientation and age, respectively. Next slide, please, Sean. Thank you. So we're back to Homer again, the former police officer, the retired police officer without the law degree, and it's Lady Hale again, and making observations this time about that change, the rationale behind that change. And you can see there, again, I've highlighted the key passage in yellow, but she said previous formulations relied on disparate impact. So if there was a significant disparity in the proportion of men affected by a requirement who could comply with it and the proportion of women who could also do so, that constituted indirect discrimination. But as pointed out here, the new formulation wasn't intended to make it more difficult to establish indirect discrimination, quite the reverse, she said, and she referred there to the account of Sir Bob Heppel. She goes on to explain, it was intended to do away with the need for statistical comparisons where no statistics might exist. It was intended to do away with the complexities involved in identifying those who could comply and those who could not, and how great the disparity had to be. Now, all that is needed is a particular disadvantage when compared with other people who do not share the characteristic. So a very clear exposition, again, of the advantages for the claimant, of course, under the new approach, as opposed to under the traditional test. Next slide, please, Sean. Excuse me. So we're going to come on now to look at some of the authorities that have dealt with the sort of key concepts under it. And as I indicated in my short introductory section, I am now straying outside strictly the time period for my chunk of this seminar. And I'm looking at the case of British Airways and Stoma, which is a 2005 case, which, as you will have clocked, predates the Equality Act, but of course it postdates the amendment of the Sex Discrimination Act to adopt that new wording that we then saw carried forward into the Equality Act. And again, there are certain things that it's impossible to ignore in the development of the case law in this area, and I thought this was a helpful one to look at. And this was a case about a female pilot who was wanting to work part-time. The employers had a scheme which meant that people could apply to work either 50% or 75% of full-time hours, and she made an application to work 50% of full-time, and that was refused, and she was only allowed to work at 75%. And in that case, it was held that the words PCP mustn't be given a narrow meaning. They're alternatives, not cumulative, and it need not be an absolute bar. This is the key part. It can allow for exceptions to be made and a provision doesn't carry an inference of being universally applicable. And then in that particular case, the employment tribunal had been entitled to find that the decision that C should not, sorry, there's a typo there, not to allow the claimant to work 50% amounted to a provision, even though it was a discretionary management decision not applying to others. So there's no requirement that the provision had actually been applied to others. So clearly a very useful development in the interpretation of what amounts to a P, a C, or a P. Number 6, next slide, please, Sean, thank you. Then moving forwards in time, again, slightly going beyond my timescale, but an interesting case nevertheless. Pendleton and Derbyshire County Council, a case on very unusual facts. The claimant here was a teacher who, she was an Anglican Christian, practicing Anglican Christian. She had an unblemished disciplinary record of her own. However, her husband, who was a head teacher in a neighbouring school, was convicted of downloading indecent images of children, and he was sentenced to a term of imprisonment. She decided to stay with him, notwithstanding his imprisonment, because of her belief in the sanctity of her marriage vows, and she was dismissed for having made that choice. The school obviously felt it was a matter that would be of concern to parents, knowing of the ongoing relationship between them. And she claimed that this amounted to indirect discrimination because of her religious beliefs. And we can see what was interesting about this case is that, as I say, it's fairly unique facts. It had never happened to anybody else. So the question of application of the PCP to the claimant and to others was quite different, potentially quite difficult to make out. But in this particular case, the evidence of the dismissing officer was very clear, and he said that he would have dismissed anybody else who found themselves in similar circumstances. And so in that case, the EAT made it clear that Section 19 allows a tribunal to look forward as well as back when they're considering whether a PCP has been applied. And of course, in that case, it had been, and therefore she was indeed placed at a disadvantage as a Christian who believed in the sanctity of her marriage. Next slide, please, Sean. Another 2016 case, XC Trains against CD. And this is a case involving, again, shift patterns and childcare responsibilities. As I've said, this has always been a very fruitful area for indirect discrimination claims. And in this case, you see there was a requirement for train drivers to be able to work 50% of rosters and to work on Saturdays. And that, she claimed, placed her at a disadvantage. She also was a single mother of 3 fairly young children at the time. The particular shifts at that employer, the system that they had in place, included either very early or very late working plus weekends, and very few shifts were available which had family-friendly hours. And it was held, the XC employed 17 women as train drivers nationally, and that formed just 3.04% of the total. And the employment tribunal concluded that women were deterred from applying because of their trying to juggle childcare responsibilities, and the difficulty then with reconciling that with compliance with the PCP. It was slightly further complicated by the fact that the request, when she put in her request to change her shifts to one of the family-friendly ones, had to go to a sort of local negotiating committee, which was very male-dominated, and both the tribunal and the employment appeal tribunals made comments to the effect that, well, you know, if you let it carry on like that, it's a male-dominated environment anyway, and if that's how you're going to let your decisions be made, it's always going to remain a male-dominated environment. So again, quite an interesting case, and I think we're on to the next slide, which I think is now for me to hand back over to Henrietta. So I'll see you in a little while.
Thank you very much indeed, Sue. Thank you very much for that important overview of some of the key principles. I'm going to try and now pick up a very constructive baton from Sue and take us through the remaining last 5 years of the existence of the Equality Act. And I'm going to try in the next part of this webinar to focus on, again, as Sue has done, some of the key concepts that we're dealing with when looking at any indirect discrimination claim. So I'm going to look at a few cases on the PCP, provision, criterion, or practice, quite a few cases on particular disadvantage, including the big hitter cases, if you like, that I'll talk about, some cases on justification, and a couple of more recent cases out of the employment law context. And I thought it might be, as we are engaging in a celebration of the Act, appropriate to try and take you through what I thought were some interesting wins. I did have an interesting list of cases that hadn't succeeded, but I thought that wouldn't be very celebratory. So I'm going to try and go through the cases in a positive and upbeat way. So can I have the next slide, please, Shan? So dealing then first with the PCP, as Sue has helpfully explained, the provision, criterion, or practice is a very helpful and flexible definition. It gives practitioners in whatever area of law you're trying to argue indirect discrimination much greater latitude than the old law used to give us. And I think there are probably many practitioners here who don't remember the old law at all, but certainly there were real challenges in meeting the old definition. And the broad thrust of the case law on PCPs is to try and be more rather than less accommodating, as Sue has said. So the case that I've got first on the slide here is Carreras. That was a case involving an employee who'd worked long hours and been involved in an accident and returned to work on reduced hours. But he continued to experience fatigue when he came back to work and headaches because of the accident. And the employer effectively began to expect that he would work later and later. He formally objected to this and said that this wasn't right, and he had an argument with the business owner. And he took an indirect discrimination claim saying that requiring him to work late hours was a PCP. So the central question in that case was really, what is a PCP in terms of how many people does it need to apply to? How widely is this to be construed? And does, in fact, the employee have to be forced into something? So here, at first instance, the ET, the Employment Tribunal, held that this was not a PCP as he'd not been required to work late. This had just been an expectation or an informal arrangement, albeit it had become a fairly clear expectation. Whereas the EAT said that was too narrow, and that the ET should have found that the expectation that he worked late was a PCP. So I think what we take from that is that this is not to be construed, a PCP is not to be construed as a requirement, because that takes us back to the old restrictive law. This isn't an element of coercion or anything of that nature. But what was sufficient here was that a pattern of repeated requests was appropriate. That was sufficient. And the expectation that he worked late created a pressure on him. And so the requirement didn't need to be any more formal or coercive, if you like, than that. So that was sufficient to generate a PCP. And then secondly, a similar point about the breadth of the PCP arose in the Ashola case. And as you'll see on the slide there, the slightly different question about PCPs in that case was about whether a one-off act can amount to a practice. The facts of that case were that the claimant had been employed by TfL, had complained about somebody else at work. The investigation had found against the claimant, who'd then gone off on sick leave for over a year and was then dismissed. The claimant brought claims against TfL, complaining that his grievances had not been addressed prior to the dismissal. And his claims included race and disability discrimination. And he argued that TfL were effectively operating a PCP of requiring a claimant to return to work without having those grievances properly concluded and investigated. The ET held that there wasn't a PCP because this was effectively a one-off act in the course of dealing with one individual. And in looking at that claim, the Court of Appeal gave some guidance on what is meant by a practice, and essentially has held that a singular decision or an action by an employer can amount to a practice, but only if it carries with it an indication that it will or would be done again in the future in a hypothetical similar case. So broadly, this is an important case on understanding, I think, the limits of what a PCP can properly be held to be. So if we can have the next slide, please, Sean. So Sue has already alluded to Essop, and I've already alluded to what I think are the big hitter cases. Sue is quite right that Homer is one, that's from 2012, but on any view in the last 5 years, Essop and Naeem are the most significant and seminal, I think, Supreme Court cases on indirect discrimination. It's very common to read judgments post Essop that purport to say, well, as Essop clearly says, things like that, or indeed as Essop clearly does not say. So this is plainly the one case, if you like, that people need to be familiar with. And in fact, I can tell you now that if there's nothing else that you need to read, if you look at the final bullet point here, as ever, Lady Hale distilled what she described as the salient features of indirect discrimination in an embarrassingly pithy and concise summary that runs over 5 or 6 paragraphs between 24 and 29 of the judgment. So in that part of the judgment, she reviewed the different iterations of indirect discrimination and pulled out what are really the common threads. And they are along these lines, and this is the crucial point really for the Essop ratio, that there is no express requirement for an explanation of the reasons why a PCP puts a protected group at disadvantage. What is essential is a causal connection between the PCP and the disadvantage suffered by the group and C. The reason for the disadvantage may not in itself be unlawful or within the control of the respondent or defendant, but both the PCP and the reason for the disadvantage have to be but for causes of the disadvantage. The PCP need not put every member of the group sharing the protected characteristic at a disadvantage. It's commonplace, she said, for disparate impact or particular disadvantage to be established by statistics, and it's always open for a respondent to show that a PCP is justified. So those were the key principles to be derived from her review of the law. The facts of Essop involved a group of individuals who alleged that the Home Office's operation of a skills assessment test was indirectly discriminatory in terms of race and or age. All of the Home Office staff had to pass this particular test, the CSA test, to be eligible for promotion. They claimed that the requirement to pass the test was a PCP, which put them at a disadvantage and was indirectly discriminatory on grounds of age or race. Statistical evidence showed that proportionately, BME and older people had a significantly lower pass rate, but neither the claimants nor the border agency, the Home Office, could establish why that was. And so that is how this case came to be significant. Essentially, the Supreme Court saying that the reason why there is a disadvantage is not a requirement that the claimant has to prove. And the linked case of Naeem, I'll have the next slide, please, if I may, Sian, which was joined and heard with Essop, was again about public sector employment. It was about the pay scales within the prison service. This was all about whether or not the pay scale, which depended on length of service, was discriminatory. And again, the context for Naeem was that there were a group of Muslim chaplains who worked for the respondent organisation. There had been a period of time when there had not been Muslim chaplains appointed. So there was a question here about whether or not the factual matrix was sufficient to show disadvantage. And again, for a similar reason to the facts of Essop, the Supreme Court reiterated that there was no causal connection required between the PCP and the reason why. And I'm just flagging now that we'll come back to these principles again and again, if you like, but we will also come back to a recent case in which, embarrassingly, I lost in the Court of Appeal on exactly these sorts of points. So I can talk to you a little bit about that case. So if I have the next slide, please, Sian. So these are now a group of what I hope are quite diverse and I hope interesting cases post Essop that take those principles from Essop and Naeem and apply them in different contexts. And as I say, sometimes if you read these cases, they all speak by saying that by reference to Essop, the Essop principles, this really clearly is the key way in which one has to understand indirect discrimination. So Gray v Mulberry, very interesting case, I thought, about an individual who worked for a design company. had a philosophical belief on her case that there was a statutory human or moral right to own copyright and moral rights in creative output. Question in that case then really was about the extent of disadvantage, what was really required here. And again, going back to the Essop principle, it is the case on the law that not all members of the protected group need to be disadvantaged by the PCP. That said, the whole thrust of indirect discrimination law is to look at some group disadvantage. And on the facts of this case, on the facts of Gray, the claimant was unable to show that others were disadvantaged by the PCP in the way that she said she was. The sole adherent of this belief, therefore, as she was on the facts, was not able to generate an indirect discrimination claim on the PCP limb. And for completeness, the court went on to say that even if there had been group disadvantage, imposing the PCP by Mulberry to protect its IP rights, if you like, and ensure its employees were aware of their obligations was likely to have been justified. So that reiterates, again, the extent of the disadvantage that needs to be shown. Have the next slide, please, Shana, if we may. And now we're coming down to one of those embarrassing defeats, but one of those try very hard and don't succeed kind of cases, which is the case of Delve that I'll talk about when we get to it. I've put McLeod and Delve together because both of these are pensions cases. So these are similar, but they are different because the pensions claims in McLeod and Sargent were to do with essentially the employment sphere. So McLeod, many of you might know, the claimant is in fact a judicial office holder. She's Master McLeod of the Queen's Bench Division of the High Court. And Sargent was the claimant in the firefighters' claim. So Master McLeod brought the claim on behalf of various members of the judicial pension scheme, and that was linked with the firefighters' pension scheme. And this was broadly all about transitional provisions in pension schemes and whether or not they discriminated on grounds of age or race or sex. And the overall ratio of McLeod and Sargent was that it hadn't been shown that the direct age discrimination in either case was justified. And so that meant, in a sense, that the indirect discrimination claim had no real consequence in the case. But the Court of Appeal nevertheless dealt with it. And again, reiterated that disadvantage did not need to be connected to the protected characteristic and found an element of indirect discrimination within the way in which the schemes had operated. The analysis again looked back at the Essop principles, and overall, the Court of Appeal was satisfied that the indirect race discrimination claim for the judges had been made out, and in the firefighters case had said if it was necessary, it would have remitted the question of disadvantage back on the grounds of on the race claim. So Delve is also a pensions case, but it's rather different because that's about the state pension. So that's about the statutory pension provision made by the government. And we tried to argue in Delve that this was no different because essentially the very, very large number of claimants in Delve were the women who were part of, I think what's the sort of hashtag, well, I know it is the hashtag back to 60 group, because they claimed unlawful age and gender discrimination because of the raising of their state pension age. They said that they had worked for many years and they had lived for many years expecting to retire at 60, and then the government had raised their state pension age in a way that meant that they hadn't, on the facts they said, had sufficient notice, and they hadn't been able to plan financially for that increased pension age, and therefore that expectation perhaps that they would work for longer. So an analogy was drawn by us with McLeod to say that this was essentially also about transitional provisions, or a bright line in legislation that says there are some people on one side of the line to whom one thing happens, and there are other people on the other side of the line to whom other things happen. And in the case of Delve on the facts, we said the drawing of that line was discriminatory. There were all sorts of complicated features of EU law that I won't necessarily, I think, need to go into. And interestingly, this was a pure public law claim, but it was argued under indirect discrimination principles. And the reason why ultimately the indirect discrimination claim failed, albeit run under Article 14, was around the causal link. So all of those principles that we get from Essop were such that when they were applied in Delve, caused us difficulties. So there was not sufficient causal link on the evidence, according to the Court of Appeal, between the withdrawal of the pension and the disadvantage. Essentially, the Court of Appeal was not persuaded that the difficult financial position that the women were in was because of that change in their pension age, but felt that it was potentially due to other factors around adverse discrimination in the workplace over previous decades. This was a massively disappointing decision, and in my view, actually, one of the key things to take from Delve, and this is straying well and truly outside the topic of this seminar, but indulge me for a moment, is that this illustrates to me very clearly the problems we face in many cases where we don't have the ability to argue combined discrimination, because this group of women were effectively required, as all claimants are on the current state of our equality law, to argue, I have been discriminated against on grounds of my age or my sex. And there isn't a widely recognised concept of arguing those two things together, whereas combined and intersectional discrimination remains the reality of many people's existence. And I would have liked to have persuaded the Court of Appeal in Delve to engage with our combined discrimination arguments more closely, but I couldn't persuade them of that. As I say, that's well and truly outside the scope of indirect discrimination, I think, but it is my little rant about what is obviously still quite a painful experience for me, so forgive me. Can I have the next slide, please, Sian? So just drawing out a few more cases, perhaps, about particular disadvantage. I've mentioned here the Gulu case, and I'll come back to that. This was a case about the local authority's housing policy, and you will see as we go through the slides quite a few housing cases. This policy provided that persons who didn't fall within a particular group entitled to reasonable preference, who'd not been resident in the borough for at least 10 years, would not qualify. Challenges were brought by a group of Irish travellers, that was the Ward case, and in this case by a Kurdish refugee. So the priority that was being given by the local authority to those who had been resident in the local area for 10 years was ultimately found to have been indirectly discriminatory. The judge had been wrong to distinguish the claimant's case on the grounds that the reason why Irish travellers were disadvantaged was known. And again, reiterating the principle that the reason why question is not to be treated in that way per Essop. Have the next slide, please, Sian. Just take these relatively briefly, just to give you an example, I think, of the breadth of subject matter that these indirect discrimination claims sometimes generate. So Hextall was also an employment case that was about the different way in which men and women were treated on shared parental leave policies. Two fathers argued that it was discriminatory on grounds of sex because under the employer's respective leave policies, men were paid less on shared parental leave than mothers were paid on statutory maternity leave. So in this case, the Court of Appeal looked at the comparator pool and how that should be defined in light of Essop. I think generally, and if Sue would agree with this, but with the new definitions of indirect discrimination that we now have, the pool question is often less problematic. It certainly used to be under the old legislation a real test, but certainly there is a need to look properly at the comparator pool. And in this case, the Court of Appeal concluded that one had to exclude from the pool those in a materially different position, as is appropriate, and that women on maternity leave were in a materially different position. And once the pool was construed in that way, then there was no disadvantage to the men. Now, OA is a non-employment case, very interesting case around student support. So this was a case involving the residence test for eligibility for student loans. And a group of women argued that the requirement of 3 years residence was indirectly discriminatory against women because they are more likely than men to be the victims of domestic violence. And one of the forms of domestic abuse is to control travel documentation, meaning that abused spouses, who are predominantly women, are more likely to have gaps in their leave to remain, and thus less likely to be able to meet this requirement of the residence test. So I think that's quite a creative use of indirect discrimination to these rather challenging and difficult facts. The government said that there was no discrimination against the women, that the requirement had to be seen in the round. The court respectively disagreed with that, and the High Court said that the requirement did in fact indirectly discriminate against the women, that again, applying Essop, one had to look at only the PCP and ask whether in isolation that put the group at a disadvantage. And then interestingly, the judgment went on to hold that there was no justification had been established for a range of reasons. And so there were some quite fact-specific points made, I think, about why justification was not made out. For example, pointing out that not all victims of domestic abuse with indefinite leave to remain would have a break in their lawful residence requirement. But again, going back to Essop and saying that there was no requirement, that the PCP put everybody in the group at disadvantage. So that was an interesting, I think, and creative use of the legislation. Let's have the next slide, please, Sian, if I may. So just a couple more cases on particular disadvantage. So Town, another police case about the movement to restricted duties for a period of time, leading to people working for the force being put on back office roles. Again, this was all about the numbers in the group subject to the disadvantage. It wasn't necessary per Essop for everybody to be subjected to it. It was enough that members of the group were more likely to be, and pregnancy triggered the policy, therefore women were more likely to be subjected to this disadvantage. Ryan was a slightly unusual case, again, about recruitment tools being used to identify future leaders. The claimant had not been a member of the recruitment pool, or the talent pool, as it was called. And statistics showed that there was a lower percentage of members of the talent pool in the claimant's age bracket compared to other age brackets. The ET considered that the claimant was an undeserving claimant, and that it was her own actions rather than the PCP which put her at the disadvantage. The EAT had relatively little difficulty in criticising that approach, and said that the proper approach was to apply Essop and say that she was at a particular disadvantage as a member of the disadvantaged group. So I can have the next slide, please, Sian. And I'll move now to a different element of the indirect discrimination test, and that is that of justification, because ultimately this is where not all, but many indirect discrimination claims find their fighting ground, if you can put it that way. So Hussain, I think, is an interesting and important case because it is a helpful reiteration of a merger, perhaps, of public and private law principles. So you'll all be familiar with the PSED, the Public Sector Equality Duty. That is generally actionable only by way of judicial review, but it can also be used in a private law claim. And what is important about Hussain is establishing that the breach of the public sector equality duty, so the failure to have due regard to the different protected characteristics, the need to foster good relations and so on, all the elements of section 149 with which you'll be familiar. Hussain establishes that a failure or a breach of the PSED can be relevant to justification in both indirect and indirect discrimination claims, and quoted Cole, which some of you may know is a case all about the disparate provision of accommodation for women who leave prison. So Cole is very interesting on its facts, is all about how female prisoners are subjected to discrimination because there is less opportunity for them to go into accommodation quite near where they live. They're much more likely to be discharged into accommodation a long way from where they live, which went to what was then, as I say, it was a seminal case at that point on the role of the PSED in direct claims. Just very briefly on the facts of Hussain, you can see that this was a claim around immigration detainees, that because of a combination of the factors you see on the slide, certain times that they were required to pray, overnight lock-in, the way in which the toilets and the rooms were set out, that there was a just unjustified discrimination against them around those arrangements. And again, the rationale for that was that the minister had simply failed to address his mind to this problem. And so for that reason, the public sector equality duty became pertinent. So that's the next slide, please, Sean. And Gulu, I've already talked about, I'll just come back to that. And briefly, that's the housing case involving the challenges made by the Kurdish refugee and by an Irish traveller. And in that case, again, it involved consideration of the public sector equality duty in a justification claim. The allocation policy prioritised people who'd been resident, as I've said, for 10 years. The equality impact assessment had completely failed to consider how that might apply to non-UK nationals. And I do think these cases are really interesting as showing a merger of the public sector equality duty, which is a freestanding duty that's JRable, with the perhaps classic private law concept of discrimination and justification. All right, so have the next slide on justification, please. The last one, I think, on this topic is the case of Heskett. I've included that because it is relevant to the sort of things that can be looked at in deciding on whether a prima facie indirect discrimination is justified, and confirms a principle that has been controversial in a series of cases, that justification can be made out on the basis of what's called the costs plus principle. So on these facts, Heskett was about a new pay policy that had been brought in by the probation service. It had an indirect discriminatory effect on significantly slowing pay progression for younger people compared to those over 50. So rather like McLeod on its facts, actually, that appeared to penalise the new joiners to a particular scheme. And in this, the Court of Appeal dismissed the appeal, saying that the combination of costs and another factor, such as the need to reduce expenditure to live within budgetary constraints, which sounds a lot like cost to me, but I think is another factor according to the Court of Appeal, and a discriminatory measure may be justified on the basis that it's a short-term solution, even if it's not a long-term one. So on any view, Heskett, which brings us up to November of last year, you'll be pleased to know, is an important and key case on justification. And I'll take the next slide, please, Charlotte. What I'll just do now is perhaps just headline for you. I'm not going to go through these cases in any detail. I've given you on the slides all of the references, just a few examples of cases where justification defences have succeeded, and not really to show any particular principle, but just to show the variety of cases that have raised these issues in recent years. So the first case is the C and work and pensions claim. That was all around the use of a computer system which indirectly discriminated against trans individuals. That was held to be justified discrimination. H and Ealing, you see there, that's a housing policy around giving priority to, working households were given priority, which indirectly discriminated against women, disabled people and the elderly, and that was found to be justified by the aim of creating sustainable communities. Get the next one, please, Sean. And Buxton is one of the benefits cap cases. That's around the work assistance scheme. You can see that that was justified the way it was constructed in order to increase the number of disabled people who could receive funds under the scheme. And then the second case on the slide there is all about the changes to the congestion charge, challenge to the Mayor of London's decision-making around that, because it was said that a large percentage of private hire vehicles were driven by those from BME backgrounds. Ultimately, that was not found to be unlawful discrimination. It was justified by the the perhaps clearer justification elements of the need to reduce traffic and congestion. The next one, please, Sean. So looking now then at a different element, and just quite briefly, because I see the time, IFOBI is an important case, a relatively recent case, perhaps for you just to flag, about the two-stage process, the burden of proof. There are plenty of cases from the employment law field on this. This case is chugging its way to the Court of Appeal, but broadly, the burden still remains on a claimant to establish facts which proved on the balance of probabilities that discrimination has occurred. I think it should say which could prove, and if that is shown, then the burden will shift. I'll just take the last few slides quite quite briefly, if I may. So just a few more examples. I wanted to end before handing back to Sue on a quite positive note. So some good wins. This is a celebration of the Equality Act. So Unison, of course, you'll all know, I'm sure, about the case where the change in tribunal fees was found to indirectly discriminate against women. It's a case, I'm sure, that's very well known to anyone practicing in employment law, or anybody who remembers trying to represent people when there were those fees in existence. Cornerstone, very interesting case around the rules of a foster agency, whether or not they were unlawfully discriminating by recruiting carers who would refrain from homosexual behaviour. That was found to be unlawful direct and indirect discrimination. I think that is part of a group of cases that are challenging what are sometimes tensions between religious beliefs and orientation, and that's being played out in a series of fora across different courts. The last cases on that slide are the ones around no DSS policies being unlawful on grounds of sex and disability. I'll take the next slide, please, Sian. Muir, another housing case, which I flagged for you. Just for Kids Law, I can perhaps talk about that because that's a win, whereas Delve was a loss. But this was a fantastically interesting and important case in which children who were in detention were, during the time of the pandemic, subject to the same extension of custody time limits as adults. And we argued on behalf of Just for Kids Law that children should really be treated differently because the impact of detention on children, and there are a disproportionate number of BME children in custody, was particularly marked. So in a range of ways, we managed to persuade the government to back down from that. And they agreed in the end to change the regulations to exempt children from that. And then the next one, please, just a few more points about perhaps some emerging issues. So Bridges, fantastically important and interesting case about facial recognition technology. That is technology that has the potential to indirectly discriminate against women and BME individuals by misidentifying people. And the decision of the Court of Appeal there was that the police force had not fully considered those consequences. So again, it's another important PSED case. I think without treading on the final slide that Sue's going to deal with about the future, on any view, that's an emerging issue, is the ability of technology to discriminate, the ability of automatic facial recognition, and indeed any other kind of predictive analysis to discriminate. Quite separately, there is work I know going on around children who are at risk of sexual exploitation. And there is technology that purports to be able to identify those children. And again, it may be that that sort of issue leads to case law in the future. I think my very last slide is just to flag the Fratilla case. That's an EU case, and it's a case all around challenges to the regulations which excluded EU nationals with a right to reside arising from pre-settled status from claiming universal credit. Quite technical, but potentially quite important, and going to the Court of Appeal. So I think with that, I'll hand back to Sue for a few more comments before we take some questions. So I think Sue's going to talk us through just a couple of points on remedy. Thank you.
Well, thank you, Henrietta. That was quite a head-spinning tour around the last 5 years of the Equality Act, and it did give a really good indication of just how broadly this act has been used and the advances it's made, and impressive to hear quite how many you were involved in as well. As Henrietta just mentioned, I'm just going to say a few words about remedy. There's one particular quirk in respect of remedies for successful claims under section 19, and it's this. You'll see it's up on the screen at the moment. Section 124, subsection 4 provides that subsection 5 will apply if the tribunal finds that the contravention is established by virtue of section 19, so it's only in relation to indirect discrimination, but is satisfied that the PCP was not applied with the intention of discriminating against the complainant. And where that has been found, the tribunal must then not make an order under subsection 2B, which is money compensation, but unless it has first considered whether to act under subsection 2A, which is a declaration, or 2C, which is a recommendation. So there's an express constraint, if you like, on the steps a tribunal has to take in those circumstances applying. So a finding of unjustified indirect sex discrimination, but that it was not intentional when it was applied to the claimant. If we can have the next slide, please, Sean. And this has been looked at recently by the Court of Appeal in the case of Wisby and Commissioner of City of London Police. So Mr. Wisby was a police officer who was an authorised firearms officer and also a rapid response driver. And he had a condition which affected his colour vision. And it's a particular condition which affects 8% of men, but only 0.25% of women. The condition had no effect on his ability to carry out his duties effectively. He'd done both roles for some years, but there was then a new testing regime and he failed a particular test because of this condition. And he was then removed from both roles, both the firearms officer role and the rapid response driving role. He was subsequently reinstated after they'd undertaken some further tests and he got through all of those okay. But it was argued that the tribunal then didn't award any money compensation, despite the fact that he'd made out his claim of indirect discrimination. So the matter was taken and then the Court of Appeal was asked to look at whether the effects of Section 124 effectively limit the tribunal's powers, and that meant therefore that it restricted the right to real and effective compensation or an effective remedy, contrary to EU law or the Convention. And also, secondly, whether it would be indirectly discriminating against women. Of course, not in the particular case of Mr. Wisby because he was a man, but because the majority of indirect discrimination claims are brought by women. The Court of Appeal disagreed and said, no, there's no particular constraint. It's just a requirement to consider all three. But I think that is something that might come back for further consideration at some point in time. And on that note, can we move on to the next slide, please, Sean? As Henrietta said earlier on, she sort of shied away from referring to too many cases where the Equality Act hadn't achieved what appears on the face of it to be equality for the claimant. And I was also a little bit reluctant. It seems a bit churlish in celebrating somebody's birthday to be too critical of them, but we thought, having known the Equality Act now for 10 years, if it were an esteemed friend or colleague, we would have no hesitation in giving them some constructive criticism as to how they might possibly be able to perform better. And that really arose out of looking at the Wisby case, and we wondered whether that might be an area where remedy could be improved, certainly to remove what the Court of Appeal says isn't a restriction, but I think properly can be read to be. The second point that I think is probably ripe for challenge is whether a claimant needs to have the particular protected characteristic in question in order to bring a claim of indirect discrimination. And you'll recall the wording of Section 19 does appear to suggest that the individual claimant does, because it refers subsection 1, a person A discriminates against another, B, if A applies to B, a PCP, which is discriminatory, in relation to a relevant protected characteristic of B. So it is quite specific, and unlike section 13 relating to direct discrimination, where it's just on grounds of a protected characteristic. And whether or not the individual does have to have the protected characteristic has been considered by the Grand Chamber of the CJEU in a Bulgarian case called Shez, which involved a challenge to the practice of a local electricity supply company. So the claimant lived in an area where there was a high proportion of residents of Roma origin. She ran a shop there, and the local electricity company had adopted the practice of placing electricity meters at a very great height, I think about 6 or 7 meters up, presumably on the assumption that they were likely to be interfered with. And that meant that this woman, who wasn't of Roma origin herself, couldn't access the meter. So she couldn't read to see whether her bills were accurate. She couldn't check her own consumption and all that sort of thing. So she brought a claim about that, although she wasn't herself of Roma origin. And the Grand Chamber of the CJEU certainly suggests that in order to enjoy protection under a claim for indirect discrimination, you don't need to share the characteristics. So that does seem to create a bit of a tension with the wording of section 19. The other area that I think is probably, well, we know it will be scrutinised fairly shortly by the Court of Appeal is the absence of availability of interim relief for claims of unfair dismissal which are discriminatory. You'll be familiar with the fact that some forms of automatic unfair dismissals, so notably whistleblowing dismissals or dismissals on grounds of trade union activity, you have the ability to apply for interim relief, which is an extremely useful measure, because if you're successful, it's a very high test you have to meet, but if you do, it's a very, very valuable measure, because it means that the employer is then required to reinstate or re-engage the claimant pending the full merits hearing. And given that we're now regularly waiting a year, 2 years for a full merits hearing, that's really quite a substantial advantage to the claimant, or it undoes the disadvantage to the claimant of having been unfairly dismissed. If the employer can't or won't reinstate, then the tribunal can make a continuation of contract order, which means that the individual is then paid their normal salary again right through until the date of the full merits hearing. But that interim relief measure is not available for discriminatory dismissals, and that's been referred to the Court of Appeal, and I think judgment is expected very shortly. The case is called Steer, S-T-E-E-R, and Stormsure, and it was the EAT found against, but they gave leave to the claimant to appeal to the Court of Appeal, because post-Brexit, the Court of Appeal can grant a declaration of incompatibility, but of course the EAT can't. So I think that is another one to keep an eye on. And talking about keeping an eye, I can see it's 4:20, so we haven't got a huge amount of time for questions. I did have a quick look in the chat bar while in the Q&A section, while Henry was doing her bit, and I can deal very happily with the first question, which is about whether or not the slides will be sent out. Henrietta and I were worrying about terribly deep and difficult questions of law that we might struggle with, but I think the answer to that is probably yes. If you provide your email address, it's been asked by an anonymous attendee. If you provide your email address, perhaps to Sian, or put it in the Q&A bar, I'm sure we can make sure that's done.
I think that's right, and it is quite a tricky question, but there's a second question on the list, Sue, which I'm happy to take. If you can look now at the third question that we've had in.
Is that the intersectional one? Are you going to?
Yeah, I'll take that one, I think, because that is quite a conceptual and difficult question. So the second question has been posed, I think, off the back of my rant about a different topic than we were actually meant to be talking about today. Why do you think our domestic law has yet to recognise intersectional discrimination, is the question. I think I need to perhaps clarify that what I was talking about and ranting about is that under the Equality Act, section 14 makes provision for combined discrimination. So that's the provision that would allow you to argue that you have been discriminated against by a combination of characteristics. And it's that provision that has not been brought into force. So as Sue says, in the spirit of critical friend, I would say, Equality Act, what on earth are you thinking? That's a really important provision that should have been brought into force. I think that this was considered in the passage of the Act in 2010, rather like the socioeconomic duty, it was parked, and I just think there hasn't been the political will to come back to it. I would say, though, and I would say this to all of you who are claimant litigators out there, that this is ripe for challenge, because under Strasbourg law, you can rely on combined discriminations. There's a well-established principle from the case of BS in Spain, and that was considered in R&A v. the Secretary of State for Health in 2017. BS is about a woman who was Black and a prostitute who established discrimination in Strasbourg principles, contrary to Article 14, by reference to the interaction of all three factors. And there is the beginnings of a case in the employment sphere from quite a while ago called DeBique, D-E-B-I-Q-U-E, that's about a person in the army. And I don't think that the Strasbourg opportunity for arguing under the Human Rights Act combined discrimination has been properly exploited. So I throw that challenge out to all 57 of you who are still here to identify the test case of combined discrimination under Article 14, and we will help take it for you, because I would quite like to take that on. But Sue, perhaps you can take the question about flexible working arrangements.
Thanks very much, Henrietta. Happy to. So the question is, are we able to talk briefly about refusing a flexible working request and how it places women at a disadvantage due to childcare commitment, the requirement to work full-time or in a different location might be the PCP? Do we agree? And I think the short answer is yes, I do agree. The problem, of course, with the flexible working, I'm just going to close the question down because I now can't see. The problem, of course, with the flexible working regime is that the remedies are very limited. There's no right to be able to work flexibly under those regulations. You have the right to make a request, and there are certain remedies if the employer fails to respond within the required time limit or doesn't give due consideration. I forget precisely the details of it, but it's a very limited right. However, I would say that making a flexible working request is a good idea, if only to help you establish the PCP, because very often the employer's response is, oh, we don't accommodate that for anyone, we can't accommodate it for you. So it's certainly the response is likely to be of evidential use if you do then go on to bring an indirect discrimination claim. Just one sort of slightly current topic, of course, on that is it will be very interesting to see precisely what employers are going to be arguing in future when they refuse flexible working requests following the pandemic, when it seems to me pretty much everyone has been able to work remotely, flexibly, you name it. And I think jobs that we previously never would have dreamed would be feasible to do from home, like this, for example. I would never have thought it was possible to do my job from home prior to the pandemic, but it has proven to be eminently doable. So it will be quite interesting to see where that takes us in the realm of flexible working more generally.
Sue, there's one more final question, which is on your pet topic of COVID employment related issues. Are we seeing inquiries from employees regarding COVID vaccination? Can an employer enforce this? I mean, that's perhaps at the margins of our topic, but do you want to have a bit of a go at that if you can?
I'll be able to tell you after tomorrow, because Louise Mancow and I are doing some training for Pennington's. I'm doing Brexit and she's doing COVID. I know, I mean, obviously at this stage, things are kind of in flux, because we know that the pandemic has given rise to a huge, we know the number of redundancy cases, for example, has increased exponentially. But we're now moving to the next phase, which is opening up. So that we think will give rise to new challenges, many of which are likely to be around things like wearing masks, exemptions from wearing masks, being vaccinated, no job, no jab is being speculated about in pretty much every article you read. And I don't think there's going to be a one-size-fits-all answer. I mean, the thing about vaccination, just to take that as a fairly obvious example, I mean, whether or not it's reasonable really and enforceable for an employer to do that will depend on the nature of the particular job, even within a setting. So even for people working in a care home, tribunal might take the view that it's perfectly reasonable to expect those staff who are hands-on dealing with the care home residents to have a vaccination, but possibly not to people who are working in the laundry or grounds maintenance or something like that. So I think that the factors that feed into those kind of decisions are going to be so various and so unique. It's going to be a long time before we see any real principles emerging.
We've had another question, I think, just a question that's come up. I think it's come up on our chat, actually. I'm not quite sure what it's relating to specifically, but the question is, how does Article 14 ECHR fit in with this? I mean, I think
it's your turn, Henry.
I think it might be. I think the short answer is much more straightforwardly, Sue, isn't it, outside the employment framework. So if you're dealing with a regular public authority decision of a police force or of a local authority, you're absolutely able to rely on the Human Rights Act in full effect. It's more difficult if you're in the employment relationship, isn't it, because of the limits to some degree of how you can argue that in the employment tribunal. It depends on the nature of the employment, I think, doesn't it, Sue, broadly? But the short answer is all bets are off in terms of the Human Rights Act otherwise, because if you have a public body that makes a decision that that is directly discriminatory or indirectly discriminatory, you can either bring a claim under the Equality Act, or more typically, you can link it with a freestanding claim under the Human Rights Act. So there is the ability to litigate a breach of all of the articles of the ECHR that are in Schedule 1 of the HRA as a private law claim, or you can rely on the ECHR arguments in a public law claim. Anyway, but in the employment context, Sue, more difficult.
Well, on a rather more mundane note, the hidden but ever helpful Sian has provided the answer to the very first question about whether the presentations will be sent round, and I'm told that they will be automatically sent to anyone who signed up for the session.
So you don't need to give us your email addresses, but you'll be getting them automatically. Last question we have, Sue, 427, over the line with 2 minutes to go. Can claimants bring a claim for institutional discrimination?
Not as a species of discrimination. It often features in claims. It's often asserted by claimants that their employer's organisation is institutionally racist. But you can't plead it as such. It's not a claim that you can bring as a freestanding one. And I think of my experience of where this has been referred to, unless there's some really good evidential basis for making it. So if there's been an independent inquiry or something like that, something like Macpherson maybe, tribunals tend to be quite wary of those sort of broad assertions, and they're much more focused on the individual treatment of the person in question, whether they can point to actual comparators who are treated better or hypothetical comparators, and that the hypothetical comparators treatment, putative treatment, makes sense, if you like, in the overall scheme of things. So I would be wary of making that assertion unless you've got a very good evidential basis for it, in my experience. Others may have other experiences, I don't know.
I think that's fair. I mean, in some senses, any claim that you bring against an institution of discrimination is effectively that claim. But I think what the question is intended to deal with is the sort of highest case, if you like, and we all know the consequences of those sort of points. So I think then, not only is it 4:30 by my time, but I actually think we've managed to deal with all of the questions that have been sent to us. If anything comes up separately that you'd like to talk about, we've put both our email addresses, I think, at the end of the slides. Very happy to take brainstorming in type interesting questions and have a chat with you about any kind of case or anything like that you want to think through. I'd like to just finish, if I may, with a short plug for the next talk that we have coming up. So for those of you who are around on the 8th of June, using the Equality Act, Rights and Remedies for Disabled People, with Oliver Lewis, Sarah Steinhardt, and Alice Irving, which will be fantastically interesting. I know that Oliver's been doing a huge amount of work around the rights of disabled people in care homes, in particular under COVID. Quite sure he'll have a lot, as will the other speakers, to share. So please do sign up. I think it just falls to me to say thank you very much indeed for attending. It's been fantastic that many of you came, and in fact that nearly 50 of you have stuck the course with us, but I hope you found it useful. I hope you've learned something, and thank you very much indeed to those who've helped us organising it. I hope you found it a useful and interesting event. Thank you very much.
Thank you for hosting, Henrietta. Done a good job.